About the elements of the crime, Anna and Zoe, and they will be guiding you through the discussion. Thanks so much and have a great event. Oh, thanks. Yes, hello. Welcome everyone. So nice of you to join us today. We will go through the first panel. The first panel is all about basic concepts of the Environmental Crime Directive. The question, how did the Environmental Crime Directive come to be? And yeah, everything around the question, so what is actually an environmental crime in the Revised Environmental Crime Directive? Yeah, how it looks now. We have some wonderful speakers with us this afternoon. We also have some research that both of us worked on the Environmental Crime Directive that we're gonna show to you. I'm sure that there will be quite a lot of questions arising during the panel. I ask you to please note them down or remember them in your head because there will be time in the end to ask them. We also have quite a diverse crowd this afternoon, how Alina already said, which is very great, but which also means that, of course, you're here with different knowledge, different experiences. We've decided to include a few more explanations so that might sound familiar to some of you already, but just at that moment think, okay, someone in the room right now is having an aha moment. That would be really great. Yeah. A little bit about us.
I'm Zoe. I study management for nonprofit organizations in Berlin and have a background in German law.
And I'm Anna. I'm doing my research master right now at the Utrecht University, and my research focuses on environmental criminal law, surprisingly. And we have some wonderful speakers with us for this panel this afternoon.
One is Michael Vorig. He's a professor at Maastricht University and Erasmus University. His areas of expertise are comparative and international private law, as well as criminal law. And
our other speaker is Roxane Chaplin. She's an environmental lawyer. She's also legal advisor to Marie Toussaint, the MEP. And her expertise lies in ecological transition, also in access to justice, and in general environmental criminal law. She has been very closely involved in the revision of the ECD, and we are in big luck this afternoon to hear a little bit from her about how this revision came to be, how the negotiations came along, and what is actually this revised ECD that we're speaking of this afternoon. I would like to invite Roxane to the stage. Please give a hand to Roxane Chaplin. We'll just make sure that the new presentation goes on smoothly.
Thanks a lot. I think it's fine. Thanks a lot for everyone for joining, and I would like to say a big thank you to you for the organization, also for the university and for the Law Hub, which is a great opportunity also to organize a conference like that. So with this presentation, first of all, I'm sorry for my French accent. I hope you will forgive this. And if you have like any trouble to understand, please say it, but I hope it will be fine. So I will try to explain a bit where the Environmental Crime Directive comes from. Why did we think that there was a need to revise this text? And what were the different steps of the negotiation until the very end? Because we just voted last week the final political agreement in the European Parliament. So well, we are at the end of the process, so it's amazing timing for you to talk about this. So regarding the origin of the directive, we can first of all say that we need to fight against environmental crime for several reasons. We think that it's one of the best legal tools that we have in order to prevent environmental damage. So there is also civil liability, but we really think that criminal liability has a very preventing and dissuasive effect on environmental damage. It's also a good legislation in order to achieve the objective of the Green Deal and the objective, the climate objective, but also the biodiversity objective that we set at EU level. I also wanted to talk and to remind that environmental crimes are growing at EU level and also at international level. So at the moment, we consider that environmental crimes are as lucrative as drug trafficking, for example, but we don't talk about those crimes. And it's now the fourth major criminal sector in the world. So we really need to fight against those crimes and also to create new legislation and to raise the sanctions in order to prevent those conducts. So I just I put some figure, but I will not explain everything. I can also send a presentation later if you want. Why we also needed a text at EU level is because, first of all, most of environmental crimes are have cross-border effects. So we also need European legislation in order to better fight against environmental crime, but also because we saw that in most EU countries, we don't have the same level of legislation. So in some countries, I will use France because I'm French, as you can see, as you can hear. In France, we have specialized police forces and also specialized courts since 2 years, but only in administrative issues. In some other countries also, there are specialized police forces, but not in all EU countries. And also there was an issue of the definition of environmental offenses, which vary a lot. If you go to France or Italy, for example, it was one of the first country, but maybe Michael Faure is not doesn't agree with that, but that has an autonomous definition of environmental crime. But there is no such an autonomous definition in all EU countries. So there is a need to harmonize this legislation, basically. So that's why we came quite early with the idea. I was too young for that. But with the idea of a directive early in the 2000s. And the issue at that time is that the Lisbon Treaty was not adopted. So the EU didn't have any competencies in criminal law. And there was an institutional conflict until a very important decision of the Court of Justice in 2005, which said that the EU could propose a legislation in environmental criminal law because it's also a tool to better fight for the protection of the environment. And thanks to that, we managed to have the directive adopted in 2008. But because at that time, the Lisbon Treaty was not endorsed yet, the directive is quite weak. So at that time, we only have 9 environmental offenses based on environmental sectoral legislation. And also, what is very interesting to see is the sanctions, which were not precise at all. They were just effective, proportionate, and dissuasive sanctions. But then member states have a lot of margin of interpretation also of the text, improvement or not, but interpretation of this text. So we have a directive since 2008, but the directive was really weak. So that's why there was a need to revise ECD. So as I said, the directive was weak and it leads to different implementation in most member states. So I will go quickly on that. But then you probably all heard about the Green Deal. So this working program on environmental legislation presented in 2019 by the European Commission. But when Marie Toussaint, so the MEP I'm working for, was elected in 2019, we just saw that the Green Deal didn't propose from the beginning any text on environmental liability. They were proposed to revise the climate law and to revise like all the files that you maybe have heard about on environmental aspects, but nothing on, for example, the revision of the Environmental Liability Directive, which is also an important text, or the Corporate Due Diligence Directive that you may have heard about as well. I'm working also on this text if you have any question on this. So that's why the Open Parliament, had a huge role on the revision of the Environmental Crime Directive, because as you probably know, the European Parliament doesn't have a legislative power. It's only the European Commission that can propose to have a new text or to revise an existing text. But since the Lisbon Treaty, we can ask the Commission to come to revise a text, to propose a new legislation with what we call an initiative report. And so we adopted in March 2021 an initiative report on liability of companies for environmental damages. And actually it's in the slide after, but I will talk about it now. We based this report, and we could do this report thanks to a study made by Michael Faure called Tackling Environmental Crime under the EU law. And in this study, so he did Michael Faure, which is here, did this study and conclude that we need to revise the ECD, so the Environmental Crime Directive, and also the ELD, the Environmental Liability Directive. So then we use this study to say, okay, we'll do an initiative report. And I used to like present a bit who worked at the European Parliament on this issue. So you can see Marie Toussaint, so she's my boss here. And Antonis Manders, so he's a MEP from EPP, so the right party in the parliament, but he's from Netherlands as well, so maybe you've heard of him. People, MEP from new, from the center, and 2 other Greens. And we try to build a coalition within the parliament. We also, during that time, organized a lot of conferences, hearings, etc., to ask experts to talk about this issue, to show that environmental crimes are important, and that we need to fight against them, etc. So without the European Parliament, the conclusion of this is that the directive wouldn't have been revised because it was not part of the program of the Green Deal. So this is the study made by Michael Faure, and we also could we can't really see the title, right? So it's a clear call from experts in criminal law, because even before the Commission published its proposal, we had this study and also some reports from experts at European level. So maybe you know, like Environmental Crime Nets, the Forum of Judges for the Environment, etc. So they all made also like some opinion, and they were calling for the revision of this text. We also had an important mobilization from the civil society. So here we can see a protest we organized with Stop Ecocide in Belgium, and the same day there was some protest organizing also in Amsterdam, I think, with Stop Ecocide Netherlands in most of the EU countries. We also created with Marie created the Ecocide Alliance. So Lamert is part of this alliance. People elected at the European Parliament, but also at national level, and which are involved in the ecocide debates. And here you can see all the NGOs that were working closely on this issue. So now, I tried to be clear, I didn't see how long I was from now, but now we are in the core of the negotiation. So all of the thing that I presented before was even before the Commission proposal was published. So the Commission published its proposal in December 2021. We consider it as a good proposal from start, even if it didn't propose a revolution or change of the structure of the text. So basically the text in 2008 was defining environmental offenses by referring to sectoral environmental legislation. So there were 9 offenses defined at that time. Now with the new text, the Commission expanded this list, but kept the list of sectoral legislation. They also increased and strengthened the sanctions. They created new articles. So basically the text in 2008 was about, I don't remember exactly, but less than 10 articles. I think it was 7 or 8 articles, so very limited. Whereas the publication made in December was about 25 articles. So really like new objective, also national strategies to fight against environmental crime. An obligation for member states to collect data, because we also know that there is not a lot of data on this issue, and a specific role of civil society and a protection of people that can have a role in the fight against environmental crime. So this was the proposal. It was not perfect, but to be honest, from the beginning it was a good text. But then we improved it in the European Parliament. So I wrote here what were the Greens' objectives within the revision. So first of all, our idea was to change the logic and to delete the list of sectoral environmental offense in order to have a general definition of environmental crime based on the consequences of the crime, but not based on the link with other sectoral legislation. But this is a huge revolution. We just tried to include it in our amendment, but it was not supported by most of the groups. But thanks to this, I would say like very important objective, we managed to have the unlawful definition, which is what we will discuss about later. The second objective we had was to include in this text the notion of ecocide with the corresponding definition, which was adopted and presented at international level by the expert panel and Stop Ecocide Foundation. So we based in our amendment, for example, we tabled a new article called ecocide with a definition and corresponding sanctions. So we wanted to include in the text like another level of environmental offense to have also the highest, the biggest offenses sanctions as such. And the idea was really to create higher sanction for those crimes. We also wanted to expand the competencies of the European Public Prosecutor, because we have a prosecutor at EU level, but it cannot prosecute environmental crime, so we wanted to do that, and also to raise the level of penalties, etc. So we didn't manage everything, but most of it at a European level, because we changed the definition of unlawful to enlarge it in order to have an autonomous definition of environmental offense. We included a so-called general clause in the European Parliament, and one on ecocide and one on a general definition. We also included a key call to expand the competences of the European Green Prosecutor, the European Prosecutor to become green, and other things. So I'll try to be quicker. It's long. So I don't know if, I guess you know a bit, but so once the Commission published its proposal, then you have negotiation within the Parliament and negotiation within the Council. So I just presented here like the main objective within the Parliament. I didn't present the council position because basically it was just that. They just deleted like half of the text and didn't want to raise the sanctions. They wanted to delete some offenses in the list, etc. So our objective after during the trilogues, when the Commission, the Parliament, and the Council negotiate again on the text, we try to make sure that we raise the ambition compared to the Commission proposal and try to convince member states, basically. So this happened between June and December. We had a lot of technical and political meetings. And we reached an agreement on November last year. So I will not develop here because I think I will be long. For me, the two major innovations in the text, and we can come back on that later, is the introduction of the so-called qualified offense. So you can see in some articles that they will talk about ecocide or not ecocide. For us, you can read the definition. The definition is aligned with the international definition of ecocide. There is no the notion of ecocide in the article, but in the recital that refers to the qualified offense, we kept and we refer directly explicitly to the notion of ecocide. So basically the recital says the qualified offense also includes cases as ecocide, and with specific examples such as like industrial, major industrial catastrophe, etc. And if you read the definition, it's really based on the international expert panel on the crime of ecocide. So this is in the text, and this is the final text. So we're quite happy with this. And also we try to create a system with higher sanctions linked to this definition. And the second major improvement of the text is, I don't know if everyone is like a lawyer here or study law. Maybe it's a very complicated topic and maybe you are lost already. I hope not. But basically, to define a crime, you have two criteria, and the unlawful criteria is the material condition. We call it like that in France. And it was defined in the text as such. So the unlawfulness was based on administrative regulation, because you can see like it needs to like respect. But a conduct is considered as unlawful if it breaches administrative regulation, basically. So this is defined in the first paragraph. But then we managed to expand this notion of unlawful with the thing that is here at the end in broad. But maybe we can come back to it because I think you will present it. So you will see. But this is a revolution, and here I quote Michael Faure. There are other improvements in the text. I will not develop it, but you can see that we switch from 8 to 20 environmental offenses. But we couldn't, for example, include a clear call to expand the competencies of the European Public Prosecutor. So this was the bar part of the negotiation. And on the sanctions as well, it was really hard to convince member states on the sanctions. So we couldn't go as far as the Parliament mandates, but we're still happy with the outcome. So I just uses some article to show the reaction after the political agreement was reached. So if you can see all the extract, the EU criminalized environmental damage comparable to ecocide. So they quote it. So it's exactly what is in the text. EU strike deal on new ecocide rules to put polluters in jail. Well, it's not only, we have a specific position on jail, but we more wanted to raise the sanctions applying to companies and based on the annual turnover more than jail and imprisonment, but this is another topic. But basically just to show you all the publication around. And the last steps, so I will stop here, was last week. So we voted, basically we have several votes at the Parliament level, but the last one is after we reach a political deal between the Commission, the Council and the Parliament, then there is another vote to just like say we agree with the deal that was reached in November. So this was last week, and we are quite happy with the results that, because as you can see, it was adopted largely. The last step will be the vote at council level. We don't expect any surprise, but I just say that at the moment, I don't know if you follow other texts, but it's a mess, and there is a right-wing say that is opposing to any legislation related to environmental issue. So I think it will be fine on this text because nobody really cares about environmental crime apparently. I mean, like really there were not a lot of people working on this topic during the negotiations. So voilà. But this will be the last votes. Then it will be officially signed, and member states will have 2 years to implement the text into national legislation because it's a directive and it's not a regulation. So voilà. I hope it was clear and not too long.
Thank you very much, Roeterseiland. Yeah, that was a very nice insight into the negotiations of the ECD. Roxanne has already touched upon some aspects that have changed now, and in her opinion, the most important changes in the ECD now. We will now touch upon two aspects that we also consider especially important in the ECD, in the revised ECD, which is the research that we've been doing at YERA Hub. It's about two thresholds that kind of are part of the question, what is an environmental crime? One of these thresholds, what Zoe is going to present, are the cognitive requirements about behind these environmental crimes. So yeah, what is the mental state of the actor? What is the mental state that an actor has to have to then be prosecuted for an environmental crime? The second threshold for environmental crime is the unlawfulness requirement that Roxanne actually already touched upon, that I'm going to also explain in column, that we think is very revolutionary as well in the revised version. And yeah, I give the mic to Zoe on the cognitive requirements around environmental crime.
Thank you very much. In general, criminal crimes have a cognitive requirement. This is called mens rea. Mens rea is fundamental in criminal law and refers to the mental state while commissioning a crime. It has various degrees from intentional wrongdoing to serious negligence, for example. In my presentation, I will touch upon the old ECD, but also the new ECD and compare it. But to get a good assess where the ECD stands, I will also touch upon other public law and other modules that define intent in different ways. So what are the requirements of the ECD with intent? Oh, I already came a bit too far, actually. Okay, perfect. The ECD states that when criminal offenses are committed intentionally, and in certain cases, also when committed with serious negligence, these certain cases conclude illegal conduct that causes death or serious injury of persons, damage, or just in general are just called very harmful. Previously, the ECD only stated that the cognitive side can conclude serious negligence and intent. So now we have a kind of like a list where we know serious negligence must be implemented, which is a very huge step in the right direction on my part. To gain a better overview, I will now touch upon the 3 stages of intent so we can better know what really the ECD means. Dolus directus is the intention to perpetrate unlawful conduct or engage in wrongful act. For an example, A shoots B to kill him. Dolus indirectus is the intention to act in a manner that will foreseeably cause a wrongful harm to another without the specific intention to cause harm. For an example, A kills B to hide, but not really with the intention to kill B. both of those really need intention, and that's a crucial part of those two versions. But dolus eventualis is only the mental state of one who foresees the possibility that a harmful or illegal consequence will result from one's act without desiring the consequence, which is a really crucial part. So serious negligence goes even further than dolus eventualis and does not require knowledge. So now I will touch upon a few other examples of public law so we can get a better overview. The Rome Statute in Article 8 state, which is a very typical example and is one of the first ecocidal crimes that touches upon the cognitive side. This article states that when intentionally launching an attack, knowing it will severely damage natural environment, it must be clearly successive in comparison to general military advantage. So here we can clearly see it touches upon the cognitive crime. Other modules really want intent is really want that intent is in the connected to ecocide, for an example. But for example, Polly Higgins, which is really connected to Stop Ecocide, wanted strict liability for ecocide, which would mean that liability is always in fact when somebody is connected to ecocide. Thank you very much. Now, Hannah. Thank you, Zoe.
Let's give a hand to Zoe. We are quite a young group. We have chosen these topics to do research on to understand how can we use the Environmental Crime Directive as a tool. And we have spoken a bit about, or Zoe has spoken about the cognitive requirements behind it. I would like to touch now upon the second threshold that we chose, which is the unlawfulness requirement. I will set myself. So, So let's start. Unlawfulness requirement. What is that? For those of you who have not had criminal law, unlawfulness requirement means if something is unlawful, it violates administrative law. I have a little bit of a background noise from the kitchen. If something is unlawful, it violates administrative law. So we have criminal law on the one hand, for example, the ECD, that really concerns itself with the biggest, most severe destruction of the environment. And then we have administrative law, which regulates the use, sadly, but also protection of the environment really in detail. And so that something is unlawful means that it violates one of the administrative laws. For example, in the EU context, that can be the Birds Directive or the Habitats Directive for you working with EU law. And the idea behind this is that we have one coherent legal system. So there should not be any act that is lawful under one regime of the law, but then actually a crime under the other regime. That's all good, and that is quite common. And there are, however, two issues with these unlawfulness requirements that were present in the old version of the directive, that, in my opinion, were quite solutioned in the revision. I have put here an extract of the unrevised version of the directive. And there's a definition of unlawful, which states that unlawful is a violation of any of the acts that are listed in the annex here. So I didn't include the annex because Annex A and Annex B are basically a long list of administrative laws on EU level. So here it was, okay, it is unlawful as soon as it violates one of these laws. The problem here, the first problem, is that the directive was made in 2008. So you have this list of laws, but all the other laws that were made after 2008 are of course not included in that. So there's a bit of a practical element there, and that is the problem. That was solved in the revision quite nicely, in my opinion. So instead of including this long list of legislation, the article says that any union law that contributes to the pursuit of one of the objections of the union in the Article 191 which is about the environmental objectives. That is, for example, protecting the environment, but also improving the environment. So that is quite, nicely solved here. The second issue, actually, with the unlawfulness requirement before the revision, and which, in my opinion, even has bigger consequences now, how it was solved, is the fact that, part of administrative law is also permits, because permits are also authoritative decisions. So this means that if a company has a permit and they comply with that permit, they're acting lawfully. So they don't fulfill the unlawfulness requirement, and therefore also they cannot commit an environmental crime. That, of course, also makes sense, because if a company has a permit, we are talking now again about the coherence of the whole legal system, they should act legally if they comply with that permit. The problem is that while a lot of permits, of course, are good and well made, there are also some permits that may set, for example, very vague requirements. So it is difficult to say, oh yeah, this company is actually not complying with that permit right now. Or they may even set requirements that violate other laws that we have in our legal system, other environmental laws. That can be because of corruption, so because of working together of the company with the authorities, but in a lot of cases, it is also, it is mostly, there was actually a report on that in Spain, where the problem is a lot that authorities work, of course, they're interested in the financial well-doing of a specific region. So they're more inclined to grant or give green light to specific projects in that region that have a financial advantage. And what has happened now in the revision, which I think is very revolutionary, is that there is a sort of exception to the unlawfulness requirement, if I may call it like that. It says that if an act is based on a permit, that act can still be unlawful if the permit is either a consequence of corruption or fraud or coercion, but also if it is in manifest breach of relevant substantive legal requirements, which is quite technical, and which we will talk more about what exactly that means. But basically, we know having a permit as a company is not per se, does not mean that that act based on a permit is per se lawful. That raises a lot of questions. For example, does a company now have to check every time they're working based on a permit if that is also lawful, if that is in line with other legislation, and what exactly are these legal requirements? A lot of questions that come up, but we are in big luck because we have a very renowned expert with us today, Michel Vogt, and we would like to ask some questions to Michel Vogt, but also to Roxane Chaplin. If you two could join us on stage, please give a warm hand. We have one mic, which means that we'll have to give it from one to the other, but which also means that we'll not be able to fight at the same time. I don't think we will. No. Yeah, thank you very much to join us this afternoon. We've been doing research into the Environmental Crime Directive, and there's some things that we know now and some things where we still have questions raising in our head. I would like to first, because we just talked about it, touch a little bit upon this unlawfulness requirement. It says that if a permit is a manifest breach of legal requirements, that is then unlawful, the act is unlawful. Could you, Michel Vogt, maybe go into that? What exactly does that mean? What can we expect from that?
Well, to provide a little bit of background, this has to do with a backbone in environmental criminal law, which is what we call the administrative dependence of environmental criminal law. Now, what does that mean? Normally, the criminal law directly protects particular interests or values, like life, property, honor. And if you breach it, you're always liable criminally. In the environment, it's different. What we do, we have an administrative system with permits. And basically what the criminal law does, it punishes the non-respect of these administrative obligations. That as such is a nice thing. What is a disadvantage? That either if there are no administrative obligations that you breach, or when you nicely follow all the conditions of administrative law, there can be no criminal liability. Let me make it a bit concrete. Not so far from here, we have a beautiful company called Tata Steel that already for a long time is emitting quite some dubious substances. In the beginning, the neighbors were accepting it because they were largely working there. After a while, they discovered that this was for their health rather dramatic. And it's not me who was saying this. There is like this pile of reports from serious government authorities who all say that living there is extremely damaging for your health. So here we talk about an environmental pollution that causes concrete danger to human health. What is the interesting thing? The Président Directeur Général of this company is interviewed on the news. The journalist asks him, what are you going to do about it? And with a big smile, he says, nothing at all. We comply with the conditions of our permit. That is exactly the problem that we talk about here. And so the question that we have been thinking about for a very long time is, would it not be possible that you say, even though you comply with the conditions of a permit, there can be criminal liability? And most agree that yes, that should be. The question is, how do you formulate that in a way that is also in accordance with the legality principle in criminal law? You can, for example, not say, yes, you're also criminally liable when there is serious pollution, because then criminal lawyers would rightly say that is a violation of what we call the lex certa principle. And so they came up by the end of the day with this idea of a manifest breach of relevant substantive legal requirements. I have to say, I like that very much. Why? What are, for example, relevant legal requirements? Pretty simple, human rights. Look now for a moment at the case law of the court in Strasbourg over the past 20 years with respect to Articles 2 and 8. You see now that increasingly, of course, in the vertical relationship towards the state, states are systematically held liable when there is a pollution of such a nature that it causes concrete danger to human health. I guess that it's not so difficult to argue what, for example, is happening with Tata Steel, but I can make a longer list. I can also go to Chemours, and I can go in Belgium to Unicor and, fill it in Italy to Taranto, Ilva, and so. All of those cases where the surrounding neighbors suffer concrete danger for human health, that amounts to human rights violations. Of course, here we apply it. I am aware of that in a horizontal relationship, but I think it's not so difficult to argue that that is a manifest breach of a relevant substantive legal requirement. Finally, if we all would be confused, and later we will be discussing about the transposition and implementation of the directive, and you say, oh dear, what is now a manifest breach of substantive legal requirements? Then I have a tip for you. There was a beautiful convention made by the Council of Europe in 1998. That beautiful convention, which to my deep regret never entered into force, had a beautiful Article 2 with an autonomous environmental crime, which had a perfect formulation, and no one was complaining that it was a violation of a lex certa principle. So my tip would be, if you don't get out of it and you have no idea anymore, go back to 26 years ago and look at that convention of 1989. That was a pretty brilliant solution to what the manifest breach of relevant substantive legal requirements would be.
Thank you very much. That was a very comprehensive answer. I was wondering when I was reading this article, Because of course now we see the end result of negotiations that have been going on for a long, long time, in which you have been quite closely involved. And I was wondering how did this article come to be? So what were, for example, other options discussed in the process, and why did it end up to be this?
Maybe I'll just. I just want to react quickly about what Michel Faure said. It's really interesting to see how you explain this administrative dependence of criminal legislation. And actually, the Environmental Crime Directive, initially in 2008, was based also a lot on the French legislation, which is already based on administrative legislation. So the criminal law in France is based on administrative legislation when it comes to environmental damages. And we really wanted to change it. So that's why we came up with this idea of environmental autonomous offenses. But I can tell that from the beginning of the negotiation, when we were using those terms, people were looking at us like, what are you talking about? And it was so hard to convince them. Well, and we had to use the examples, and we were actually exchanging a lot during the negotiation with Michel Faure, because I was like, can you send me examples, like concrete examples that I can tell to the negotiator that we need to have this permit defense to go through it. I don't know how to say it, but yeah, to change it. Also, we had some examples in France, for example, the accident of Reeterseiland. It's an industry in Rouen, and because the industry also like respects all the administrative permits, we couldn't prosecute them on the criminal aspects. So yeah, I just wanted to say I just wanted to say that it was hard to introduce this concept into the negotiation discussion. And when you talk about the convention at the Council of Europe, we also have to know that currently there are ongoing negotiations. So indeed, there was a text in 1898, which was never ratified because there was only 3 states at Council of Europe, I think, that signed it. But now, currently, they are talking about the new convention, and they're revising it. And they are using a lot the work we did at EU level. So it's really interesting to see that what we did, what we achieved at EU level could also be achieved at the Council of Europe level. And what is helping us, well, it's a bit a pity, but Ukraine is part of the Council of Europe, and Ukraine has, for example, ecocide in the criminal law. So they are fighting a lot to also have a new article on ecocide on this convention. So we can see, yes, what could be done at the Council of Europe also. Now I'm going to the question, sorry. Quickly, I said it at the beginning, our amendment, the objective was to delete the list and just to have a general definition of what could be environmental offenses. And we wanted to have like several levels of gravity. And we wanted to define environmental offenses based on the consequences you can see on the ground, and not based on the fact that this conduct respects or not this legislation. It's a bit precise, but we try to do that. And in the EP position, we didn't manage to have our amendment adopted, but we include something that is closer to this in the definition of in the article. But any directive has to be read both from the article and the recital, because the recital is here to explain what is in the article. And in the corresponding recital in the parliament position, so not the final position of the text, but the final position, we include something which is really interesting, is that the concept of the older know or should have known, knew or should have known, that his conduct was unlawful or didn't respect, like, the idea behind is that if you don't respect environmental principles, such as the precautionary principle, the preventive principle, you can be prosecuted under criminal law, even if you had a permit. So we tried to expand this in a recital. This recital didn't survive in the final version of the text. But now what we have here, but I think it's really interesting to have in mind the recital, because it would be also a huge issue for the implementation. And for the moment, the manifest breach of relevant substantial legal requirement should refer to an obvious and substantial contradiction with substantive legal requirements. This does not include breaches of procedural requirements or minor elements covered under the authorization. And this link a lot with what you said earlier about the fact that we also need to respect general principle of criminal law, of the fact that the law needs to be very precise. So we try to do this here to exclude minor elements, minor breaches, but only cover manifest breach of legal requirements. So voila, but yeah, it was a huge fight until the end. And maybe if you see this written, you would think it's just small, like few words, but actually it's changing everything. And yeah, it will be transposed. We'll see how, but I think it's a good step.
Yeah, that's also what I think. It's yeah, it's a small paragraph, but it changes a lot about the way that we think about permits and about being allowed to do something. Yeah, I really think that it is quite revolutionary, and I do think though that it is put in a quite, I mean, it's not put in a technical way, but it is for those of you who do not have a legal background, maybe not so easy to not so, you don't notice in the beginning like that this is something that is gonna change quite a lot, and that can also be used as a tool, especially for environmental organizations, for anyone working with the law, working with this directive. Quite promising. I'm not sure how much. Nice. We still have a little bit of time to talk, and then take some questions from the. I get a nod. Yeah, we have. I would like. Oh, for wanting to join us. I would like to touch upon the other threshold that we talked about, the cognitive requirements behind. Because we think that these cognitive requirements, or the questions about it, are quite particular in environmental criminal law to other parts of criminal law, because it is very difficult to prove intent in environmental criminal law. Is there, question to Michel Vore, what is your opinion on this difficulty to prove intent in environmental criminal law? Do you see any difference to other parts of criminal law?
I'll give you a couple of comments on that. First of all, I think it's important in the legislation that you make things for the prosecutor as easy as possible. So there, I mean, you were mentioning, Zoe, I think that you lowered the level down to serious negligence. I think that makes a lot of sense. If you put in intent, that's a hopeless case, unless you are in a country, jurisdiction, where they interpret intent in a very broad manner. And so I think serious negligence, that should be it. Otherwise, it's impossible to prove cases. I also have to say, if you look at the practice in France, in Belgium, the Netherlands, where there have been quite a few cases, several cases, environmental cases prosecuted, it is, to my knowledge, never that those cases have not been successful because of the intent requirement. In other words, I have never seen cases where there was an acquittal because suddenly the judge said, oh dear, we had a polluter here who had really no idea what he was doing. If that is really the case, then those cases are not prosecuted. So in that sense, you also have to be a bit relativistic. In most of the cases, it is either pretty clear for the polluter what is going on, or at least there is serious negligence. And so, yeah, that's all I have to say for the moment.
Quick follow-up on that, actually, because that is quite interesting, especially if we look at this article. Because here we established that a company can be prosecuted even though they have a permit. And now if we think about intent and about proving intent, how do you prove that someone, has knowledge of what they're doing that was wrong if they have a permit that allows it to them?
But, the whole crucial issue of the autonomous crime is that you now provide an enormous important signal to industry, to the operator. Before the operator had a permit and they could sleep ever after for 30 years and do nothing anymore, no research, would not matter whether they were violating human rights. That's over from now on. The only thing that we can really be lucky about is that this is apparently so complicated that the business world has no idea what they got into. I think that's, according to me, the only reason why this got accepted. Therefore, I would like to ask you, don't tell anyone what is really there, because otherwise we don't make it by April. I still find it a miracle that this has passed. And afterwards, they will realize what this means. What does this mean? It means, indeed, that if you comply with the conditions of a permit, that's a minimum. From now on, hey, you have to respect human rights. Strange, eh? And that is now explicitly going on. You have to avoid that you cause emissions and pollutions that may cause concrete danger to human health. Strange, eh? So you need to do research. And that is the crucial point of this. You now impose an active duty of care in order to do examination, in order to do research, in order to keep innovating your environmental policy on the polluter. And so that is also the nice thing for the prosecutor, depending on how this will be interpreted and how it will be transposed also, that you can say, look, you comply with the conditions of a permit, but we look at the consequences. We see that here your emissions are causing concrete danger to human health. Look at Tata, look at Chemours, look what the PFAS is causing to all the people living around there. There is RIVM reports, big like this. The prosecutor can use that. Nowadays not, because we have administrative dependence. But with this, and the prosecutor doesn't have to prove any intent. Judge General mens rea services. And the bastards get prosecuted and convicted. Yes!
Thank you very much. Do you have something to add?
Yeah, just to react also on what you just said. I think it's interesting to mention that during the negotiation, there was a lot of lobbies, I would say, around this topic. I still don't know why. Maybe it's too technical, maybe it's too transversal, maybe it's a bit weird to lobby against criminal liability, right? Because even companies they don't want to commit crime, but even they commit crime sometimes. But so that's why we were able to reach this outcome, because lobbyists were not involved in the negotiation. We didn't receive any proposal from the industry, from bad lobbyists, I would say. And it's really strange because I work on other issues, and I was talking earlier about due diligence directive. This is different, and I don't know if you know, but the text was rejected last week at council level because all the companies are really scared and afraid of this legislation. But actually, I don't understand why it's not the same for Environmental Crime Directive. So that's why, wait a bit before April to say to everyone that it's revolutionary. But we really think that it would be a new tool, very important. And after April, I really think that civil society, but experts, NGOs, and everyone should talk about this issue, should have also a good interpretation and broad interpretation, and we'll talk about it later as well, in order to show the revolution that it is.
Thank you. I would like to take a little bit of time now if there are any questions from the audience. Are there any questions from the audience? So we can, otherwise I have a lot of, because I heard we have 5 minutes left, so we can take 1 or 2, and then I have, I don't know.
Or maybe
I'm gonna repeat it on the mic for the people that are joining online. That's okay.
Okay. I also don't know if this is extending the scope of your research or anything, but I was also wondering, especially because you talked about corruption, for example, also in connection with the permits, and that maybe even the authority issuing the permits made mistakes. Is there any movement authorities also under the prosecution, or is there a different route to justice in that regard? If the harm is, or that part of the harm is also caused actually by the authorities.
Do you want to repeat the question?
Maybe you can answer in a way that
Okay, do you want to start?
You know, the point that you make is about liability of the public authorities. And you know, Roxanne and I, when we are pleading in favor of autonomous environmental crimes, we often get the comment that you make, that people say, hey, look, what you are showing here is that apparently there was a bad permit. Apparently that permit should not have been given. Why don't you look at liability, maybe criminal liability of the public authorities? Well, the answer is this is not always the case where authorities have knowingly been setting wrong standards. I'm not saying, for example, that the authority who gave the permit to Tata, that they were corrupted or that they were wrong or that they knowingly did this. Sometimes it is simply an issue that emissions change, that consequences change, and that at the moment you provided the permit, you could not foresee how it evolved. Generally, let me tell you honestly, I am against criminal public authority liability for the simple reason that I think it will create chilling effects. The only thing that public authorities will do then is try to avoid liability and not make decisions in the public interest anymore. And I think second, that it shifts away the attention from where it belongs, with the polluter. That's why I hear very often journalists also asking me, there should be public authority liability. My answer for the reasons I gave you is no. We should focus on the operators and lay the responsibility from where the emissions come and not bother the good, willing, public interest guys who really, civil servants who try to make permits in the public interest. I think the cases of real corruption, there may be one. Let me tell you, in my career, I'm an old guy, I've seen a lot. I have not seen in Europe many cases where it was clear that civil servants were corrupted and that for that reason, bad permits were granted.
Yes, and maybe if you can read on the screen, you already have corruption included in the definition of unlawful. So actually it's in any case like included in the exception of the unlawfulness requirements. If you can prove that there was corruption, then it's fine and you can prosecute. On this, we also tried to include the criminal liability of public authorities. Just to make also a debate around that, because in the text there is a definition of legal person, and in this definition they exclude explicitly public authorities from the definition. We kept this exclusion, but we included in a recital the fact that member states can go further, and if they want to create criminal liability for public body, they can do. But I will talk more about the French context, because in France we have like a separation between judicial and administrative bodies, and so we can, and there are a lot of cases. For example, I come from an environmental NGO who did the first climate action against the French state, so we can like ask demander des comptes.
Ask an injunction, basically.
Yes, but like ask public authorities to
be accountable.
To be accountable, thanks to administrative liability. So we can use also both. And the idea to separate criminal and administrative liability is to have different tools. To use administrative liability when you can prove that the permit shouldn't have been taken and given. Or use criminal liability when you can prove that the company didn't respect the permit or didn't like act in a precautionary way. And I wanted also to say that the issue we can see in France, but I think in most of the EU countries, is that you don't have enough public authorities that can see if the permit is respected or not. So sometimes you have companies that had a permit 10 years ago, but then there was not like inspection. And every year in France, the number of environmental inspectors is going down, whereas you have more and more industry polluting. So this is also an issue that we try to avoid with criminal liability and with this notion of permit defense that is maybe not existing anymore.
Yeah, thank you very much. Very interesting question. We have to round up, but before we do that, I have kind of a bridging question to Roxanne, because we have a second panel after this, which will be all about the transposition of the ECD into national law and implementation of the ECD. Thank you very much to Michelle for getting that training, so you have to run with it. My question would be whether you already touched upon it a little bit, whether there are any things in the directive that are, in your opinion, vaguely formulated and where you see a danger of once now it is transposed into national law, that it might be transposed ineffectively or not with the same intention that you drafted it.
Yeah, so I think that we already talked about the unlawful and the interpretation of what you can see in the screen, especially the addition. I wanted, maybe we didn't talk about this before, but I wanted to talk about the sanctions part. Because in those articles, the member states or the council wanted to include so the sanctions applying to legal person, the most important sections applying to legal person or the fines. And to define the fines, the judge can do several. There are several methods to determine a fine. And we wanted to include only a fine that will be defined based on the annual turnover of the company. Because by doing that, you ensure that a company such as Total, which has a huge annual turnover, would be very dissuaded to do damage, because it could be a huge thing to pay for them at the end. But the member states, so the council, insists until the very end of the negotiation to keep an alternative method, which is only to have fixed amount of fine. So it means that a company such as Total or a small or medium-sized company would pay the same amount. And this is an option. And member states, when they will implement the text, will have the option rather to choose for a fine based on the annual turnover and a percentage of the annual turnover, which could be 5 until 5%, which can be a lot for some companies, and a fixed amount. So this is, for example, a choice that we let open in the text. So it's not really about interpretation, it's more about a choice. And some other parts of the text are about interpretation, and I think we talked about it.
Thank you very much. Thank you very much, Roxanne Sarplan. Let's give a warm hand to many. We will now have a break, and then panel 2 starting at
No.
Anna. In 10 minutes. Thank you very much.
Okay, so welcome to the second panel. We will be talking about the implementation deficit and. Okay, great. So, welcome to the second panel. We will be talking about the implementation deficit and the transposition of the ECD, also the revised version. And the implementation deficit, just to shortly summarize, on the one, it's about the effectiveness of the directive. And on the one hand, due to a large discretion afforded to member states, and on the other hand, due to maybe the wrong implementation by member states. But first of all, who are we? Yeah, okay. Stanimira is a bachelor student of European Studies with a major in EU law, and she did research on illegal logging in Bulgaria and therefore the implementation deficit in Bulgaria, not only because illegal logging is a big thing in Bulgaria, but also because she herself is Bulgarian and therefore has quite some better access to documents also regarding the language barrier. I'm Leah. I do my master's in EU law here at the UVA. And I then looked at the safety net for individuals and whether this implementation deficit with consequences as such in Bulgaria could then be challenged in national courts. We also have amazing speakers today.
Yes. So as so we introduced ourselves, but here are our panelists, and welcome to them. That's the first one is Mr. Lambert van Rand, who is a party member of the PVDD and has been in the House of Representatives of the Netherlands. Now he's a member of the Fraud Policy and Services Inquiry Committee, and his areas of expertise are economics, management, finance, climate policy, energy, aviation, and ICT, as well as Mr. Alberto Nicotina, who is a PhD in constitutional law at the University of Antwerp, and now junior lecturer for EU law at UVA, and his areas of expertise are EU multi-level governance, EU constitutional law, populism, and democratic representations of national constitutionalism. And here's my presentation, which is on the shortcomings of the 2008 Environmental Crime Directive. Yes, my research mainly focuses at first on the Revised Environmental Crime Directive, basically on Article 5 and Article 7 for the penalties for natural and legal persons. And here, what we could say about the problem with those two articles is the fact that they are really vague in the exposition of the sanctioning mechanism, and they only state that the offenses in Article 3 and 4 are punishable by effective, proportionate, and dissuasive criminal penalties, which does not clearly portray a sanctioning mechanism standard for the member states to implement in their national legislations. And sorry for that. So now I would like to give just a brief background on the transposition within the member states' legislations. So the directive, as was mentioned previously, had been issued in 2008 and had to be transposed into national legislation of the member states. And generally, the sanctioning levels for member states were in the range of approximately 1,000 euros up to the maximum, which is 5 million euros, which was rarely charged, unfortunately. And as well as prison sentences, which were in cases of extremely severe cases connected to death. However, what could be said as the rationale why member states did impose such low fines is the fact that environmental crimes are hidden impact crimes, which do not directly victimize the habitats, the animals, and the humans, as well as their surroundings. And the effects of the crimes have to be, time has to pass for these effects to actually show, for them to be seen, and actually for humans to try to go to court for these offenses. And here we can see, for example, in the
in Germany and in France, how much the fines were, and as well as for the intent and for the negligence. And we can see that this is just a range of it, but actually in practice, those fines were rarely imposed. And here is a statistic from the Eurojust website, where we can see that environmental crimes are on the rise, and the sanctioning mechanism keeps lacking a set common standard for minimum and maximum fines in the EU. Now to the actual point of my research, which is the practical side of the sanctioning mechanism. I will focus on the illegal logging problem in Bulgaria. And actually, the illegal logging should be kind of determined what it actually consists of. So it occurs when timber is harvested and sold illegally. And in most cases, this timber actually is also derived from endangered species of trees. And in recent, in these articles, they also explain a recent issue in one of the mountains in Bulgaria, where in a check from the authorities, they found 5 types of trees that were of birch and aspen, which are endangered species. And actually, 1/3 of the logging in Bulgaria is actually illegal. And according to the WWF report for 2023, 2.7 million cubic meters annual volume of timber were found. And actually, what illegal logging actually does is that it leads to deforestation in the habitats. And after that, this causes losses of wildlife, and it also contributes to air quality's worsening, because when there's less trees in the nature, after a while, the air quality worsens in the cities and there's less access to oxygen. And actually, the fines in Bulgaria for this issue are extremely low. For natural persons, the fines are between 26 to 1,050 euros, and for companies from 50 euros to 2,500 euros. And also another issue is in the lack of enforcement of this directive is the fact that there's lack of reports. So there's definitely an issue with the awareness of the problem, as witnesses rarely report this crime. And also a problem in the authorities themselves, because forest rangers are also understaffed and cannot tackle cases of extremely dangerous illegal operators who are part of an organized crime group. And 33% of the violations are penalized as a result, which is extremely low. And finally, what could be also mentioned is that a huge part of this crime contributes to losses to the EU budget, as well as to Bulgaria's budget as well. So around annually, Bulgaria loses around 50 million euros, and the EU loses between 80 and 230 billion euros from this crime. And now, how has the issue been solved? Well, as Roxanne mentioned, now there's actually more stricter mechanism regarding sanctions, which I have outlined, that now there's imprisonment for natural persons of between 3 to 10 years, depending on the type of offense. And now the fines are determined based on the seriousness of the offense and the financial circumstances, as well as the proportionality and the duration of the damage and the irreversibility of the damage to the environment. And for legal persons, there's a 3 and 5% total worldwide turnover for the companies, and 24 to 40 million euros fine, depending on the offense. And this is the end of my presentation, and I basically outlined the revised ECD's ineffective enforcement in member states legislation, the legal logic in terms of the law fines, and the new amendments potential for prosecuting and environmental crime. Now I give the floor to Neil.
So as we have now seen, the practical consequences of the implementation deficit, in my research, with a very long title, Providing the Missing Thread, the Implementation Deficit and a Safety Net for Individuals in the Revised ECD, have looked at whether individuals can challenge this implementation deficit in national courts. But first, let us go one step back. The ECD says that member states shall take the appropriate measures to tackle environmental crime. Normally, the Commission is the one that acts if a member state fails to transpose a directive or other EU law. But what happens if it's not about failing to transpose the directive? It is then for the wider public, such as individuals or NGOs, to take over this supervisory role in order to ensure the effective directive. So, can we do anything for an effective directive as individuals? As I try to line out a bit here, there might be a safety net provided for us by EU law in order to, as individuals, safeguard the effective directive and not fall into this implementation deficit. However, what is our safety net in this case, or is there even a safety net? As the court provided us with such a safety net in Domingos, a case by the CGEU, there are 3 possibilities for individuals to challenge or to rely on their rights arising from EU law in national courts, which would be, on the one hand, direct effect, indirect effect, and state liability. And we'll see whether these 3 options would be a good option for the Environmental Crime Directive, or whether there are still some flaws. Firstly, direct effect, a small revision. Individuals can rely on their rights arising from EU law if a provision is clear, precise, and unconditional, as we already know from Van Gent and Os way back. However, a directive, provisions in directive are barely clear, precise, and unconditional, and mainly there is discretion afforded to member states. However, member states cannot simply not transpose a directive or just not transpose and deny the rights to individuals and rely on their own non-transposition or their own wrongdoing, which is basically the estoppel principle. So the problem that still remains is that we are in the realm of substantive criminal law, meaning in procedural criminal law, one could say that there are procedural rights arising from the directive in order, for example, to victims rely on their rights. But in substantive criminal law, there's a little difference here. There are no rights conferred onto individuals, and as the court itself held, the obligations that arise from this directive or from EU law, they cannot be relied upon by the state against individuals. That is the main problem. And as has already been spoken about in the previous panel, legal certainty is also a big issue. And even though legal certainty has improved by more defining in the revised directive, by more defining the sanctions and the penalties, and also the recital that you talked about before, that is not about minor breaches, but it has to be a manifest breach. This is true. However, it is still the case that that the state cannot rely on obligations in order to sanction individuals, and individuals still need to know what they can do and what they can do. And if it's just not transposed into national law correctly, then that is not the case. So, direct effect, it is not. Is it indirect effect? Well, indirect effect, interpreting basically national law or in national court proceedings in light of the directive, according to the general principles. Would that be an option here? Well, we still have the same problem with legal certainty and foreseeability. And as I've said before, it has improved after the revision, but still you cannot simply interpret away national law, which gives legal certainty to individuals solely because there's a directive, even though the directive has not been transposed. I hope I don't lose you here already. It's a bit technical, but it is also not indirect effect that we can rely on. Last but not least, state liability. That is normally the last resource that individuals can recourse to. And it is if there's a manifest breach of EU law, if it's sufficiently serious and if there's a causal link. But it must be the party injured that asks these damages. Who is the party injured in this case? It is rather the environment and not individuals. So if I may sum up, because that leads us to follow-up questions in a broader context. There are no rights conferred onto individuals by the Environmental Crime Directive. There's no party injured. And therefore the question is there maybe rights of nature that nature is then basically the party injured? And how do we defend these rights in national courts? Could there be standing for the rights of nature, maybe in the light of concepts like successor in title or other concepts? Yeah, how would we defend these rights? And a little note that I want to give in the end also is, yes, the implementation deficit has been reduced by the revision of the Environmental Crime Directive because there's less discretion for member states and also then more legal certainty for individuals, but the above things still prevail, unfortunately. And now I invite our two panel speakers to also come on stage for some questions that we have prepared and also maybe some questions that arise from the audience. Yeah. You make questions, please. Wherever you like. Okay, maybe some first remarks. Firstly, do you have any questions yourself or any comments or any additions to the presentations that we just made, or should we simply jump into the questions?
I mean, couple of things. So I guess I'm here for my past, my dark past. I worked a couple of years as an environmental lawyer in Italy, and it is from this perspective that I want to say something. I noted something during the previous panel. There's one thing I think is important to take into account, which is that of course there are a lot of bad people who pollute. There are a lot of bad companies who pollute, but there are a lot of good people and good companies who run their business in a normal way. For these companies, most of the time, compliance is a very expensive thing. We saw it, for example, with the General Data Protection Regulation, GDPR, an amazing objective, which charges company with huge amount of paperwork. And in the end, those who have more money get away better with paperwork. Then some practical thing. So soil pollution, for example, take soil pollution. The principle is polluter pays, but most of the time in practice, the problem is who is the polluter? If you have a site that is used by industrial plants since the 1950s, And you have a company today running that site, and today it is found that there is pollution in that soil. How can you establish the responsibility? It's a huge problem that still is kind of unsolved. Of course, then there's a problem of the intent of the company. How can you prove the intent of the company? Of course, it is the management. But what does exactly mean the intent to pollute? No company will never find on paper, let's pollute. It's a bit more complicated than that. And then, from a very personal perspective, working in environmental law, working in a law firm, made me understand that there are public authorities at the regional and local level are very close to law firms and companies and compliance departments of companies. Most of the time in a good way. So they know each other, we call each other by name, and this exposes us a huge risk of corruption. We most of the time did paperwork for public authorities, for employees in public authorities, because we wanted them to like us. We didn't, I mean, during my experience, we didn't corrupt anybody, but the risk is there and is very, very important. So just for context, maybe.
Okay, thank you very much for these insights. Do you also have anything?
No, let's go to the question.
Okay. Okay. So the first question that I've written down was, well, you have not looked per se into criminal law, and you also feel free to answer this question, but I mainly directed this question to Alberto.
Okay.
You're very familiar with climate litigation. With climate litigation, would you say that the ECD forms a good basis for individuals to help preserve the environment? That's a very vague question, but also linked with what I said in my presentation at the end: the rights to nature, rights of nature, but maybe also the right to nature. Is it a must, the rights of nature or a right to nature? For preserving the environment as an individual, also in light of legal certainty, which, yeah, is the big problematic here to litigate in courts. But what is your picture about that?
So I have clear ideas on the second part, if the right of nature is indispensable for bringing to court cases. It is useful, but it is not indispensable. The problem is who brings the cases to court, which is indeed environmental NGOs. So I would say the two things are equivalent: either the right, both the right of nature and the substitution. So the wider capacity of NGOs to bring complaint to court. So the legal standing of environmental NGOs. If this directive help or will help, the new version will definitely help more cases to be brought to court. Again, it is not an indispensable, like criminal liability is not, in my opinion, at least, an indispensable tool. We saw it in Uganda, we saw it in Belgium with klimaatzaak. So I would say it will help, but not really. It will help.
I think the rights of nature is and will be indispensable. In the previous panel, we talked about, or there was discussion on the coherence of law. And to my opinion, and I hope also to your opinion as students of law, the house of law cannot be complete when the destruction of nature is not included in the law. And therefore we, my party, YERA, also sees the rights of nature as the next step in, I would say, emancipation to make this coherence of the law more complete. But I do agree with you that you don't need it per se to prosecute. However, we see it as a necessary next step in actually in civilization. And therefore it will be part of it, and therefore it is necessary. And therefore we included it in the law that we introduced in the Netherlands.
If I may ask a follow-up question there, the law that you introduced in the Netherlands, maybe you can fill the audience a bit in how, yeah, also what the rights of nature play, which role it played therein.
Yeah, so there's been a process of many persons. First of all, I did not do it alone. I worked with a lot of students, actually. So there was and I think it's also very hopeful, I hope for you, to see also in this meeting how a small group of dedicated persons, Roxanne is one of those, Michael Fowler, and we with a small group of persons are really changing the law. So that, because, let me, if I may, 3 points I want to make. First of all, we are in a climate crisis. So we are in the 6th extinction wave, and the laws are not appropriate. Second point you have to realize is that the opposing powers of economics are immense. And to that extent, it's amazing that the European Crime Directive went unopposed, under the radar, which will help a lot. But the third thing that I want to point out is law is very conservative. So to introduce new things in law is very hard, because the lawmakers I met have as a first instinct, can't be done. So therefore YERA is so important. You guys are so important to have this innovative way of thinking in your studies and in group. So back to the law. So what we did, we worked. I personally worked 10 years on this type of initiative, inspired by Polly Higgins, of course, inspired by Lilia, who is there, by Stop Ecocide. And there's 3 things we put in the law. First of all, the rights of nature. So it's a crime in itself to destroy nature. To kill nature is a crime in itself. It doesn't have to be damaging for people, for instance. So that's the first step we did. The second step is that we removed this administrative dependency. So the crime in itself, if you is punishable. So in fact, we introduced the crime as a higher order, that to deal in a way that causes ecocide, or you are neglecting to prohibit ecocide, then you're punishable as well. And the third element we introduced is that when a citizen of the Netherlands commits a crime abroad, we also go after him. Well, the prosecutor goes after him. Because, and now, of course, in this law coherence game that needs to change, if a deed of ecocide is not prohibited, if deforestation in Brazil is not prohibited, you cannot prosecute here in the Netherlands. So this double indemnity, we also remove that. So those 3 elements are very crucial in the Dutch law that we proposed. We started this like 2.5 years ago to really go to criminal law. We submitted it in a consultation round, and then the European Crime Directive was sort of, I think to my remembrance, it was accelerated. So we really had to change our Dutch law to be in coherence with the European Crime Directive. But I think, so we have it. So the transposition has been done already, with a few twists. I think we made it more, I would say, progressive than the ECB now is, but that is allowed. So you can make it stronger, more punishable. So this is what we did.
Now you touched upon actually 2 issues that I also wanted to touch upon. Firstly, we heard before also from Roxanne that the European Public Prosecutor could play a role. Unfortunately, it didn't go through. But how would you imagine the role of the European Public Prosecutor on the one hand? And on the other hand, you also touched upon, it's a double question, so bear with me. The second part touches upon the minimum harmonization on EU level. that's maybe a personal question, you don't have to answer it politically or academically correct, but would you say that minimum harmonization of environmental crime or EU law, environmental law is the way to go, or would you rather say there should be a full harmonization or more harmonization in a sense?
First of all, I really like the name YERA because it's research and advocacy, because you cannot do both without, and it's without each other. You cannot do advocacy without research, you cannot do research if it's pointless. So, and it brings me to the point that indeed, minimum harmonization is what we have in criminal law. We also have to understand what we can ask the European Union to do, because the principle of conferral forces the EU to act only in a limited amount of competencies in limited areas. Besides the treaties, when it's about EU criminal law, they talk more about approximation of laws rather than harmonization. And there's like scholars who say like approximation is something a bit less than harmonization. It's bringing them as close to each other as possible. And this is what the European Public Prosecutor can do could do in practice in the future, if any possibility there will be, trying to indeed use the national institutions, the national public prosecutors, to bring about a change. And bringing about a change in criminal law at EU level is very difficult. We know also with very famous cases, if you take Tarico, for example, that harmonizing criminal law across the EU is very complicated. Tarico was about the limited termination periods foreseen by Italian law for tax evasion. And the VAT is a tax that is has a EU relevance. So the EU was very interested in prosecuting crimes and getting money out of people who evaded VAT. But the Italian system was, and the principle of legality was mentioned earlier, didn't allow the Italian authorities to prosecute that crime after 10 years. And eventually the European Court of Justice said, true, principle of legality is more important in this case. So harmonizing criminal law is very difficult, and that's why advocacy is important. The best way to ensure implementation of EU law is by advocating, is by lobbying in political activities. I would say it's almost the only way. The second big problem in EU law in general is not much about implementation, is about enforcement and technical capabilities of national, regional, local institutions to actually have the expertise to enforce legislation.
Thank you very much. I would give the mic on. Yeah.
Yeah, only to say that I largely agree with Alberto in that getting a European unity is very hard. And we don't have that much time, to be honest. So I would focus my energy or Dutch energy on getting the best possible ecocide law nationally, be a driver of that, and then see who follows, to be honest. In harmonizing, well, it's a concept. Once you've seen it and grasped it, you cannot unsee it. As for the European prosecutor, I don't have any strong opinions on it, to be honest. We firmly believe, from a party point of view, that the legislation should be in the Netherlands and national. So I don't have a strong opinion.
Thank you very much. We have time for. Yeah, I see the nod. Then I will give the mic to Nina for questions.
Well, my questions are mainly directed towards Mr. Van Raan, but I also encourage you to participate. My first question is because I took a look at the Netherlands approach towards the environmental crimes and how crimes are actually prosecuted and what's the deficiencies in the enforcement of the directive. And my first question is, as a person who has been working in the spheres of consultancy, organization, management, and finances, among others, what additional policy measures and strategies do you think are most promising for fostering cooperation and information sharing among law enforcement agencies, and environmental organizations in the Netherlands and within the EU.
Thank you. Quick question. Thank you. And so what I've noticed in the work in Parliament, convincing to have, for instance, cooperation or getting after the polluters. The role of information in Parliament and talking about destruction, for instance, biomass, like you did, has not much, didn't have much impact. And then all of a sudden, I think it was more by luck than design, we were speaking on companies who were losing their license to operate in the eye of the public. And then all of a sudden, we noticed that we got traction on the subject. So for instance, Statuspeel or the biomass centrale Vattenfall, speaking about losing license to operate in the eye of the public, then somebody gets scared. Then you get phones from the companies themselves saying, "Oh, shall we talk about this?" And so I think the role of the public and NGOs is extremely important. As for the exchange of information, well, let me put it this way: the omgevingsdiensten in the Netherlands and the services, they work together. They now work since 4 years. They have a thing called what's it called? I wrote it down. Object view, where they share information on the various companies, and the various agencies share a lot of information, and because that really helps. On a European level, of course, you have Interpol, Europol, and the more the ECD crime directive, once it's signed and once all the it's transposed, I think you will see a very strong interest in sharing that data. For now, from what I understand and hear, it's a bit messy, but it really will help. As long, for instance, that we don't make the mistake of starting to share information without making sure we respect privacy. Because, for instance, the Netherlands have a very long and tragic track record in first starting to share information and then think about privacy. So it's, yeah.
Well, before we shoot all our questions, maybe there are some questions in the audience. If any, then please raise your hand and shout out.
Yeah, I have a question to Lambert van Raan, because you've spoken about the Dutch ecocide law, which I also think is yeah, a very big achievement. And I was wondering what are the concrete effects that the ECD implementation will have yeah, on this Dutch law? Because you said that of course the Dutch law, or no, of course, the Dutch law is quite ambitious, so there's quite a lot of points where the Dutch law is more ambitious. Is there also something where the ECD is more ambitious and where the Dutch law has to adjust to, maybe?
Maybe if you could repeat the question in a short form for the online audience.
Yeah, and I will look at you closely to see if I do it correctly. So are there elements in the ECD that are, for instance, more advanced than in the local, I would say local Dutch initiative? Well, I have to look at it. Maybe we should do a study on the comparison. To be honest, I don't think so. I don't think there are, but the main thing, and that is the very important thing that was achieved with the ECD, thanks to people like Roeterseiland, is that it mentions the crime of ecocide. And that alone is a tremendous boost also for the Netherlands, for the Dutch initiative. Because here we are fairly aware of what ecocide is and how it works, and etc. But the larger public has no idea. And the fact that you can say, okay, well, it will come from Europe anyway, more or less. If we go into the nitty-gritty, it's very different. But in general, and this is how politics works, in general, say, okay, we have to have a law regardless because Europe wants it, then it helps tremendously. As for the more advanced elements in the ECD, Roxanne, do you know the Dutch initiative a bit? Have you seen?
No, so that's-
No, we come back to that.
Would be interesting to listen.
The next YERA
Yes.
summit, we will report back to you.
Yeah, thanks.
Thanks for the question.
Are there any other questions?
I think there's a question in the chat, maybe you can.
Wow. Maybe just a complaint, actually, as those.
That's the first can unmute. This is not the chat.
Maybe you can repeat
Is
it?
there technical support?
You could ask them to unmute and then they can.
Yeah. I don't see your questions in the chat. Maybe you can unmute yourself, online audience, and then ask your question out loud.
Yeah, shall I? Should I go?
Go for it then.
Please. Yeah, and please introduce yourself as well, maybe. Yeah, some words.
Yeah. Okay, thank you. Dani Spizzichino. I'm managing the Italian campaign of Stop Ecocide International, and I'm doing a PhD in law on ecocide. So first of all, thanks everyone for your presentations. Thanks to the panelists. My question would regard corporate criminal liability of companies, and given that I didn't see it in the ECD text, if you see it coming in the near future, something like the freezing of companies' assets for severe environmental damage. Because usually companies have their budget implies penalties for their wrongdoings. So maybe going beyond the corporate veil, freezing their assets would have an impact on their behavior. Thank you.
Okay. Maybe also one of either of you, and then maybe also it would be interesting to see what Roxanne thinks about it, if she wants to spontaneously join panel 2 as well. Yeah, so, but otherwise.
Yeah, very quickly, maybe.
Yeah.
Yeah, very quickly, before giving the floor to Roxanne, I think this would be a matter for the implementation of the transposition of the directive. And that could be, if I think, for example, of Italy, my jurisdiction of origin, that could be done very easily and would be very much in line with what we have seen, and that would come as a consequence, at least, of the sanctions.
While you come here. So we are in the Netherlands, we're focused on prosecuting persons. So they go to jail or pay, so it's more directed to the persons. However, freezing assets is also a possibility, of course. But you already have some instruments for that. Maybe this is the point where the ECD directive goes further than Dutch sidebar, right? Thanks.
Just quickly, because I'm not supposed to talk now. So on ECD, you have a specific article for liability of legal person, which is the Article 6, where we also wanted to introduce in this article specific focus on corporate board members. So we didn't include it in the article, but we included it in the recital to say that if individually people can be prosecuted, so as natural person, it means it doesn't limit the legal person to be also prosecuted. So both can be prosecuted. So if someone takes a decision in the company, it can be prosecuted as a natural person, and the company itself can be prosecuted. So you have both liability. And then when it comes to the sanctions, so we talked about a lot about the fines, which is the most important sanctions. But in the Article 7, you will also find a list of accessory sanctions where we included, for example, the suspension of public funding, the suspension of the activity or the end of the activity if the crime, if the environmental offense is too important. And you also have an article, so I think it's the article 10, about freezing and confiscation of assets, where we precise also that we can do that. So it's included in the text. And maybe just to answer the other question before about the law in Netherlands, because I didn't look at it, so maybe I don't know. But what I was saying before about the national strategy to combat, to fight against environmental crime and data collection is something also new that was not in the directive in 2008. And maybe it would be also added in the law in Netherlands. And I was thinking also, sorry, because I was writing a lot of things during your presentation, about the rights of nature and the role of civil society and public participation. At the beginning, we wanted to include in the text, so there is an article on public participation in proceeding, it's Article 14, and we wanted to include in this article a possibility for any citizens and any NGO to do a complaint to the prosecutor so that he will launch the prosecution. But we didn't manage to have this. So in the text, you have the possibility of for a citizen and NGO to talk about the voice of nature during the proceedings, but they cannot start the proceeding. And we also included provision on access to information about the state of proceedings and about also the rulings and the sanctions. That's all the things of the text that I couldn't mention before, so now I
Don't give her the mic.
Maybe 1 second, if you before you go back.
Sorry.
Because I think the question that I asked took us some time actually.
Yes, we are.
Okay.
Take 1 minute, and there's another question actually also connected to the rights of nature.
In the chat.
Yeah.
Oh, okay. Should we have the question maybe first? But okay, I'm first going to ask a question. What I asked before, the role of the European Public Prosecutor, how, from your perspective, then it would be very interesting. How was this role imagined by the European Parliament then in the end?
So I don't know if everybody is familiar with the EPPO, but it's an European institution created in 2019, and it can, for the moment, only prosecute financial crimes. So there are some people that already think that because environmental crime and financial crime sometimes are very linked, that EPPO has already sort of powers to prosecute environmental crime, but it's not written in the treaties, and the regulation that created EPPO really limited his role to financial crimes at EU level. And we consider that because environmental crimes often have cross-border implications, that the EPPO at EU level, because also it should be independent from administrative authorities, could launch proceedings against environmental crime that can happen. Sometimes you have environmental crime between France and Italy. It's often the case for waste trafficking, for example, or like wildlife trafficking, this kind of thing. So he could launch this case. But the issue we faced during the negotiation that we couldn't give EPPO environmental competencies with the revision of the ECD. We had to change, first of all, the treaties, and also the regulation that created EPPO. But it's something that we still have in mind, and we might change in the treaties in a few years, we hope, to enlarge what you were saying before, to enable the EU to go further in criminal legislation, because you have the Article 83 of the treaties. So the first paragraph is on the most serious criminal issues, where you have, I don't remember, like, but I think corruption or like important criminal aspects, criminal issues. And the second paragraph is only about minimal harmonization, So the directive is based on the second paragraph, and we want to include environmental crime in the first paragraph. I don't know if I'm clear, but to consider environmental crimes as the most serious environmental, criminal issues at the EU level, such as gender-based.
It's very insightful, and I would have a lot of follow-up questions actually. But so maybe I'm gonna ask chat, the person that asked the question in the chat, which I don't see because I cannot use the cursor. Maybe you can unmute yourself as well and ask your question out loud.
So I wasn't the person asking the question, but I'm the online moderator. And basically the question is, can you expand a bit more about the connection of rights of nature with the ECD, if I understood the connection, if I understood the question well?
Sorry, can you repeat the question? I wasn't.
Yeah, can you hear me all right?
Yes, sorry, I was just a bit distracted by the cursor. Is this question directed to me per se because I held the presentation, or is the question directed to the panelists? Whom would you like to answer the question?
So it's not my question, but I'm relaying it. And I think mostly to the panelists. So the connection between the rights of nature and the ECD.
Yeah, originally we discussed about whether having rights of nature could, make it more effective, the directive more effective. What I was mentioning earlier, you have cases, and I was saying that in my opinion is not strictly necessary, as you said, it would be indeed a good way to close the circle and make it full, guarantee of full protection. As for example, we have the example of animals. In many member states, the crimes against animals are protected not because we recognize rights to animals themselves, but because by law we gave the association who protects the animals the capacity to go to court and have legal stand. So if we have that, we could actually make the directive more effective. Yeah. To complete my previous answer.
No, I
Okay.
animals have, to put it bluntly, animals have the same rights as toilet paper.
Yeah.
And that's horrible.
Very quickly, one note on the European Public Prosecutor. Another issue a bit under investigated of a public prosecutor is the, again, technical capacity to do things. If you look, for example, at Czech Republic, you have a lot of European public prosecutors who are linked to the European public prosecutors. If you look at France, that's only in Paris. That says a lot about how member states are organized and how much the national organization of the judiciary and like really small administrative things can have a huge impact on the implementation and enforcement of EU law.
Okay, so it's there's no time.
Unless you have another question, but we could also have a break in 6 minutes.
Oh, okay. Well, if there's no question from your side, then I think we are more or less happy with the. Break.
I'm also exactly while I'm asking a follow-up question to that, because you touched on a lot of different legal aspects and legal instruments that Chile already has, and I was just wondering to start with Marco, maybe if you can talk a little bit about sort of current obstacles, but also where the Chilean environmental law has obstacles, but also points of potential when realizing protection of the environment.
Yeah, thank you for that amazing question. I think any law, when you take a look at them, when you're reading them, you always think this law could be better, or this law can change, you know? The thing is, when people are making these laws, when the people that are the parliament, or in our case, in the Congress, not all of them are thinking in that way. That's the first thing. Sometimes they're just thinking, okay, let's create this. Let's try to put it out so the people can see it. But once it's working, when you need to use it, once it's at the courts and the judges need to take it into consideration, then is when you see the real problems. So I think obstacles, they're going to be in the future. Advantages, yeah, I prefer to be positive about this. And as Fernanda was mentioning, I also agree that we have many things to celebrate now. I remember that not so long ago, when you were committing a crime here against nature, then the sanction was, okay, you need to take ethics classes. And I think Fernanda remembers this very well. So if you take that point of start, you know, of course we have a big progress here. I know that for other countries, it's not like a big deal, maybe, always thinking we need to go higher, and I agree with that. But when you see that not so long ago we were sending these people to take classes, you know, after big crimes against nature, now you think, okay, we have something good, and we need to be grateful for that, even when it could be better. And I think we're in the right path, and hopefully this is just the beginning of that. So yeah, thank you for that question.
Fernanda, would you like to react to this as well? Add a little bit your point of view?
Yeah, I mean, maybe add what Michael was saying, that it's also kind of improved slowly after the ethic lessons. There were the penalties with a little bit economic sort of like the multas, sort of like that you pay, and
fines.
then yeah, besides, sort of like you include them in the budget. The companies have them included in the budget, so it doesn't have any impact. And now, I mean, with the new law, just to be in the positive side, I mean, it's sort of like if you avoid the environmental impact assessment, you are avoiding, intentionally avoiding to, I mean, you are kind of like being illegal in the way that, and then if you are, even though you have a permit, like Lambert was explaining in the last panel, that even though like you, oh, in the first panel it was, I remember, even though you avoid, I mean, you have the permission to have the company and and you I mean, you extract too much, you destroy nature, etc. There are few elements in the law also that are a little bit more specific, but I mean, now you are committing a crime. So from that gap, what Marco was saying, we have a wonderful law as well. We have a new law that it recognizes climate change. Then now how all these elements, legal instruments that we have from before, that we have a basic law, environmental law that is 19,300. That is the basic, I mean, it's the base of all the environmental laws, plus this new penal code paragraph. It's sort of create a crime. It's not just a sort of like a civil crime. Now it's a penal, as a sort of like, it's a, I don't know, you can go to jail for even 10 years and you have big fines and you need to restore. Now, how it's going to work, we don't know. And that is when we come in to try to advise, I guess, to the people who need to invest the money and create the reinforcement offices and etc.
Yeah, I think my follow-up question on that is if you see any gaps of how the law is designed and how it's sort of applied in practice, as far as you can tell so far.
That was for me or to Fernanda?
To either, but feel free to start, Marco.
You first, yeah.
Okay, yeah, well, it's a big challenge. Of course, we can't see the future, but we know that for sure it's going to be a challenge. Many times you see beautiful words in law and documents, and the truth is, after some years or when you need to put this into action, as I said before, then it's when you can realize why we didn't do this in this way, why this doesn't have a regulation more specific. Sometimes here we have two different codes, you know, how to work. We have the criminal code, but also a procedural code. So sometimes they are not aligned, you know. So sometimes we have there the law that it's saying, okay, this person needs to be in jail. But then when you see how, it's not matching with especially with new laws. So the whole legal system needs to walk or to run, let's say, hopefully to run in the same direction. And sometimes when you are putting the political will in one aspect, you can clap for that and it's great, but you need a whole perspective to make this legal system to walk in the same direction. If not, you're gonna have like a table, you know, with one side like this, you know, so it's not gonna work even when you have very good intentions. So I think maybe now we could be in that situation, but we will see. Hopefully it's gonna work.
Yeah, and also to explain is how the laws are created in Chile, they're all amendments of existing laws. So it's very difficult to create new laws because either way you need to put things that they were in the past and then you modernize, I guess, some paragraphs, you include some words. So it's very difficult in the political will or in the work, depending of the configuration politically in the moment, because sometimes some proposals are very good in the moment, and they get stuck there forever and changes maybe one or two governments. And then next time, sort of like somebody take it out, dig it out of the pile of laws or amendments. And maybe you need to recalibrate and renegotiate and everything. And it changed so much in, let's say, in technology and also in the type of crisis that we are right now. So as Marco would say, it's very difficult to go accordingly to the times that we require laws and the enforcement of laws. So we have created a law or many laws the last 5 years. But regarding the environment, I think it's going to take another 10 to actually see the effects of all the new laws in a good place to perhaps make them work. And perhaps there had to be many other work in the way just to repair the mistakes that they have been created now with these loopholes of things that they doesn't really go with each other. So it's a never-ending work, I guess.
Yeah, and if I can add something very briefly, because I know that we need to respect time, but there are some ideas coming up. So yeah, I really like balance with these things. I like to be fair with everything. So I'm thinking about two situations. One is positive and one is negative. The first one, the positive thing about this that I'd like to mention is that here in Chile we have a state view, a state vision of what climate change is. So even when we've been having different administrations from the right wing and now more from the left wing, you can see that there's a commitment with climate change because this is coming from the state. And one proof of that is that we have now a framework law on climate change in the country that started with one administration and now it's working with a new one. So there's a state vision of the whole system in about climate change. So I think that's something very positive because some countries, when they're changing to a new administration, they also change the vision that they have about climate change, like the US, for example. So, and that's the positive thing. Now, the negative thing is taking the words that Fernanda was saying. We have a political constitution, as maybe you already know, that it's from 1980, and it was created during our dictatorship. And even if it had many modifications during all these years, you can still feel and see that there are some limitations because of this constitution. So even when you have a strong vision from the state about this issue, there are some limitations, like the ones that Fernanda was mentioning, and this big limitation because it's the constitution. It's not just an ordinary law. So yeah, thanks for that.
Yeah, thank you. I really enjoyed the sort of balanced approach to it as well. I think that was very clear. Just to sort of bring it back to the ECD, and I know obviously you may not be an EU law, either of you EU law experts. So I was just wondering, to begin with you, Marco, maybe you've heard a lot about the ECD today and sort of how it can help protect the environment or protect, sort of our natural environment from being polluted and I'm just wondering if, from your perspective, do you think, if possible, the ECD should have some kind of extraterritorial jurisdiction? So, for example, a European company based in Europe but committing environmental crimes in Chile, would it make sense for the EU to be prosecuting, for an EU member state to be prosecuting that company? Would that make the environmental protection efforts more effective? I'm just curious about your kind of view on this.
Yeah, thank you for that amazing question. I don't know who was behind this amazing question, but I need to say congrats to that person or to that group of people. But it's amazing, yes. Yeah, well, here I know that I'm not the owner of the truth or what needs to be done, you know. It's just my opinion, but I think the ECD, if it should have extra territorial jurisdiction. Well, for that you need an agreement between countries. You need a political vision that allows this to happen. And if you have those ingredients, then you can make this work. However, you're gonna have challenges in the meantime. And I think especially with sovereignty, to who needs to be in charge of this, because as I said before, when things are happening, it's when you see the real obstacles. Before that, everything it seems nice because they're just words on people or words on documents. So you need to face the challenges or the problems, let's say, to wait, you know, this new document, this new institution. And I think here we will face that situation. But going straight to my opinion, I think it could work. But one of the criteria that we should take into consideration, in my opinion, it would be who has the stronger institution or the stronger sanctions for this crime. Because in your example, an EU company will be here committing crimes against nature. So if Chile has a very strong institution, a very strong law, the CEO of that company should be in jail here, should be in prison. But we don't know what could happen with if we are taking into consideration the EU law facing the same situation. And so I think in the ideal scenario, we should take into consideration, okay, who has the best institution for this, and who has the stronger penalty for this situation. And with that, I think we can get to a point to understand who needs to take this situation, who's in charge of this situation, and always thinking who has the strongest sanction against this.
Okay, and that's a very like the stronger the better. I like that. Fernanda, what's your view on this?
Well, I think that maybe would be fair. A part of all what Marco was saying is that it should be an instrument in the countries that agree to have these sanctions from origin, or let's say at least an assessment, environmental assessment, and economic sort of a due diligence, let's say, from the country of procedure. I think it would be fair that if there is something wrong, the country that it's sort of like the nationality of the company to sort of stop it and make it better before it enters our territory. And because even though our law right now, as the economic law that we have now, economic crimes law, as it looks now, it's a bit stronger than it looks easily, in the way that in the paragraph 13, it has a more specific sort of the how and what more specific. So I feel that the ECD is a little bit ambiguous, let's say, and I will collect what Emert was saying, that it's very important that the nature gets in the center of the conversation, not the business or the profit. I think that for me is something that we need to change a little bit the way of seeing how, for example, Chile, that it has a very strong economic treaty with Europe, we pay the price, because now with the new renewables energies, we have the lithium, we have hydrogen, we have a lot of very good things that Europe wants them all. So it's very hard to because our economy is based on exports and the progress of the mining industry, and et cetera, it's very hard to shift also from our perspective how to value nature without selling all to the Europeans, right? So I think it has to be a strong balance, and I agree with Marcus that depends of the institution which is the strongest, and I guess because of size, and if all the members of the European community sort of agree to have an enforce by origins of all this, maybe it will be stronger from Europe. But as it is right now, we can persecute the companies that avoid, let's say, the procedure in our country, even though they have the permission, even though that is illegal. I mean, most of the companies surpass all the permissions. And because we have the fine, and because we have this, everything gets in the same sort of like, we know what's happening, but we cannot change it because it's legal. So it's very hard. It's really hard. But yes, I think it should be from Europe come the push to our country to modernize also the treaty, and also includes all these new fantastic innovations from Europe in the treaties. I think it has to go by hand. So that's it.
Okay, thank you. Yeah, I really enjoyed both of your insights, actually. I have many more questions, but I think it might be good to give the floor to the audience, see if they have any questions for you. Maybe people in the physical audience or the online audience can raise their hand. I can hear you very softly.
At this moment, there are no questions from the physical audience. So if you, Hassan, you can go ahead.
Okay, amazing. Because I have so many questions. No, I think it was just a follow-up question for what you were saying last, Fernanda, because you were saying that obviously a lot of the sort of Chilean economy is based on extractivism, and you have a lot of sort of economic interest, or as Chile's economy, a lot of economic interest in being able to export things to Europe. So sort of aligning, would that be, I think my question is, what advantages would there be for Chile to like align their environmental law with European environmental law? So obviously sort of from a economic standpoint, but then maybe there's also some disadvantages of why you would or wouldn't want to align your environmental law with European environmental law. I don't know if I'm making myself very clear.
Yeah, I mean, if in the hypothesis that they are in place in both sides, just to get into the positive side, right? It would be fantastic that we could have transparency, that we could have the information previous the decisions or the discussions, that it could be a possibility of participation by the communities, the territories, that they are the ones who suffer the consequences of all this. I would love that it could be binding, all these opinions, with all the, let's say, the impacts of the environment of the company also be transparent in what it is. And then we can sort of maybe have possibilities to investigate ourselves and to have a sort of like a comparisons of all this. I don't know, I would love that all these ingredients of transparency, communication, participation, it could be included in both sides. And in the treaty right now, for example, just to put it like that, you can only see our treaty between Europe and in Chile in English, published in the page of European Commission. But we don't have the publication in Spanish. We have not been informed of the discussions. So we don't know, I mean, we know what is being negotiated because we have been digging in, but because it's not open, not many people knows what it is. Everybody is sort of like believing that it's a good thing. So I think information is the key from both sides, because we are engaged in this situation. We know about what's happening, but I believe neither in Europe as in Chile, not many people knows what's happening in the European Parliament or in the commissions. So that's, I think, a very important sort of ingredient that I think is missing for everybody to read, everybody to follow, everybody to participate, I think. And transparency is the key.
Yeah, thank you. Marco, do you want to react to that?
Yeah, I was thinking that there are many challenges there with what Fernanda was saying about information. I think it's key. I agree with that. It's key for both sides to know what's happening. I understand that the European Union is bigger and the challengers are bigger too. But here there is a mission of the European Union in Chile. And I think they also have work to do about information to people. Like, of course, Chile can say we are doing this with the European Union, but also since we have representation of the European Union here in Chile, they can also say, hey, we are working on this with the country. And if you check social media, for example, you can see the results of the conversations, but not what's happening in between, you know, so it's not completely clear. So I think there's a challenge there about the information for the people. I agree with Fernanda about that point.
Thank you. Yeah, thank you so much. Bob's asked a question in the chat. Would you want to unmute yourself and ask the question, Bobs? Otherwise, I can ask it as well. I don't know.
Hi, can you see me or can you hear me?
We can hear you.
Yes.
Oh yeah, we can see you now as well.
Yeah, sorry, I'm in the dark here. I was wondering if you could elaborate a bit more on local territories and local communities' views on the degradation of ecosystems in their living environment and water sources being depleted or privatized due to extractivism of natural resources that Europe needs for its energy transition.
Okay, there is a strong criticism, let's say, for most of the community from top to bottom. There's some more strong end views because they have the impact either by climate change and also the industry really nearby. So they don't really trust so much about what is happening above them and who are taking decisions. So they're very critic to what's happening either way, which doesn't matter what is happening, they're all very critic. And unfortunately, because we are in a very remote area in Chile and we have a north, it's a very dry and barren. The communities, they suffer by drought every year more and more. I mean, it's very hard. The fishing industry is also suffering because there is it's a big industry as well that is taking over the small the small fishery, right? The fishermen. So community, as a sort of the bigger is the industry, the bigger is the impact in the communities, right? And territories are very diverse. As I said, we have the north, so it's basically based in what it is. Let's say they have some animals, some llamas that they have, and they don't have much possibilities, but they depend from water and some vegetation, and they don't have much. And then in the middle, we have the mines, of course, the copper and everything in the north. So all the economic is based in that, but the communities don't receive any let's say improvement from that profit. I mean, they're very isolated communities, right? Indigenous as well. And in the central area, we have other type of mining. We also have a lot of, because of the mine and the agriculture use a lot of water resources, and also climate change is sort of melting our reservoirs of water with the ice. Let's say, what is the name? Iceberg? No, glaciers. So it's sort of drying down, and the very deep water reserves, they're really dry. So the community itself, they're the ones who suffer firsthand all this, let's say, climate change for one hand, but also the impact of the industry in their own territories and in their own situations. And in the south, we have fires, big fires, because we have monoculture, etc., etc. We have also salmon farming. Most of them, they're Norwegian. So I don't include them in the package of Europe, but I mean, we have a lot of situations all over the country that it sort of takes a lot of power, and it's getting more and difficult for the communities, and displacement, fires, etc.
Yeah, thank you so much. I think it's just really important to we started with this very legal, technical panel and just bringing it back to, okay, but how is this happening in real life? How is it affecting communities right now as we speak? And I think that's really wonderful that we've had this whole range of insights and perspectives tonight. I think I'm gonna round off unless either one of you still would like to add something.
Yeah, maybe just to add to the last thing, sorry to interrupt, but I think it's very important to also mention that in Chile, we have so many activism and also let's say environmental defenders all over the country, and they're very articulated as a sort of like, they are working. I mean, they are walking the walk, and they're doing the thing, and they know a lot about legal procedures, and they doing their own thing. Sometimes they get advice by some sort of scholars, of course, and everything is moving. But because there is no transparency, there is no participation binding, there it's a very frustrating path, and it's very hard. It's also a lot of persecution. It's also threats. There have been killings, I mean, crimes for protectors of the environment. The little indigenous people we have, they are always under threat by the industry because of the progress. Society is moving around, many people is moving to the places. So it's an historic battle with the indigenous because they have been, let's say, taken out of the let's say, natural places. So they are battling to recover them. So and it's further down in the south, so it's not very present to the very centralized government or activities or happenings. So yeah, I don't know, it's a very difficult environment to work because it's not very connected from top to bottom. The being the present in the, let's say, going to make a march for the environment or because of this or that problem, it's very hard because there's no people who is going to mobilize all the way down to the south, all the way from the south to the center. Or it's a very, very niche kind of let's say, yeah, activities or processes and celebrations. I don't know. It's a family in a way. It's a family trying to survive. Yeah, so we know each other in a way.
Yeah, that's really, really wonderful. And it's very inspiring to hear all of these different people from all over the world, obviously fighting for the same thing. And I think we all take different routes, and some take a more legal, diplomatic route, and others take a more activism route. But I think being here tonight has just really shown that it's really important to collaborate. So I just want to thank you both so much for joining today and for your wonderful insights. I'm just gonna share the last screen and hand the mic back to Alina, who is going to close it off in person. But thank you both so much for being here tonight.
Thank you so much for having us. Very much.
Thank you very much. It was a real pleasure.
Okay, thanks so much, all you guys. I think it was an amazing event. Thank you, online audience and speakers. Glad that you're here, and I hope we can keep in touch. That's the same for you. I hope we could generate some insights, and now the impact lies with you. So you carry out what you learned and hopefully act on it. Because we don't only want to generate insights, but we want to make sure that they actually protect the environment and the people. And so I think this is how we would like to conclude the event. But first, we did have some kind of a brain drain in terms of speakers, but we have two left, and Lydia. And I would like to ask you to come on the stage because we do have a little present for you as a thank you. So, thank you all.
Sustainable presence.
I don't know if there's anyone from the law hub here anymore, but they will find a present. So thank you so much. I think in the name of the entire team. And well, thank you so much again.
Perfect.
Thank
Thank you.
Yeah, thank you very much, all of you. We will still have some drinks and some snacks. I'm not sure whether we can, how long we can stay here, or if we, for those who want to talk, move on to the. Yeah, we do have a seat reserved for Korea, but we also have drinks enough, so you can also hang around.
And I think before we conclude everything, this was not only us talking or the people who were speaking on the panels, but also an entire advocacy team, an entire research team. And I think we are very proud of what we did in the last 6 months, from having an idea to creating an event and actually doing research and getting out to people who have such an interesting perspective. So I would like everyone from the YERA team, even though they take amazing pictures and they are responsible for opening more doors on the stage. Thank you, I think, for your job and your amazing work. So please join. Open in half. So I guess this is just to present you with the team. This is the YERA Hub, and there's many more things to come in the future. Guys, I'm very proud of you. I think Anna as well.
Yes, and I must say for this evening, I think, yeah, I'm very proud of us, and a lot of things have gone really well. We have some minor things that, yeah, we will learn, and hopefully in many more of these research events on a lot of different issues around EU environmental law, or just, yeah, in general, environmental issues in Europe. Yeah, we'll see you there again. Yeah, it was very nice to have you stay in contact, and let's have a, yeah, a chat, a little drink, a little snack.
Thanks so much.
I will be hanging up the Zoom call now, but thank you everyone and have a really good evening.
Thank you, Lotte.
Thank you very much, Lotte. I'm sorry that I'm gonna miss the drinks.
Yeah, me
Yes.
too. I wish I was there as
Yeah.
well.
No, yeah.
Pero you are in Spain? No, you are in.
Yeah,
Yeah.
I'm in Barcelona.
And you speak Spanish?
I do, yeah. Not Catalan yet, but Spanish I do, yeah.
Oh, Catalan is hard, I think.
I think so, yeah. So when I was just like, oh, I get to talk to people from Chile, I'm so excited. Yeah.
Oh,
So
in the
you speak in
beginning,
Spanish.
Yeah.
it's difficult for me to talk a topic I speak only Spanish. To translate, my brain in the beginning, I was like, what is the name of the law? I couldn't translate it in my brain. Like, but yeah.
No,
Thank you, Wolf. Thank you, Rainer. Thank you, Lise. Steve.
Yeah, thanks so much for joining for such a long online event. It's I think I'm going to turn off my computer soon.
Yes. Marco,
Thank you very
good to
much.
see you.
Sí, igualmente, Fernanda, como siempre. Mucho
Nos
gusto de
tenemos que
verte.
hablar, poner al día. Estuvo
Sí,
chota la
por supuesto.
conversación.
I agree.
Un abracito.
Bye bye.
Okay, bye. Have a nice
Bye.
evening.
Thank you so much. Bye
Ciao,
bye.
ciao.